welcome to this session in our Power Series CLE. My name is Mark Brasher. I'm a partner in our corporate practice, focused heavily on data center and power infrastructure development. And we've got a really interesting program today discussing some of the trends in litigation that are emerging around digital infrastructure with my litigation colleagues. So I'd like to introduce our panelists. First off, Chris Popov is the head of our complex commercial disputes practice. Chris sits on our management committee and handles much of the high-profile litigation that passes through the firm, with an increasing focus on litigation emerging from digital infrastructure transactions. Patrick Traylor sits in our Washington office in our environmental group. Before joining V&E, Patrick was Deputy Assistant Administrator at the EPA, where he supervised the agency's Clean Air Act docket. And Patrick is at the forefront of environmental litigation concerning data center projects, working on a number of very high-profile environmental matters at the moment. Jeff Jakubiak joins from our New York office. He's one of our prominent FERC partners, tracks everything going on at the FERC. It's obviously been a very interesting summer, and over the last few years, Jeff's been very busy advising our clients as they look to invest in and develop data center projects. And lastly, Jeff Swigert from our Dallas office is a patent litigator, is very active in the eastern and western districts of Texas, and is seeing a lot of emerging trends in patent litigation around data centers. So just to set the table for today's discussion, I lead our firm's projects practice, and we cover a wide variety of digital infrastructure and power infrastructure projects related to data centers. And in combination with our M&A colleagues and our finance practice, we're seeing activity across the capital stack, and really a wide variety of transactions, including joint ventures, asset acquisitions and dispositions, finance transactions, construction, project development, and one of the things that really characterizes all of these transactions that I think is unique in infrastructure booms that we've seen is the urgency with which these deals are getting done. I don't think there's ever been so much of a focus on speed, and with that comes increased risk. And this is all in the context of, by far, the largest deployment of capital we've ever seen into an asset class. So there's a huge amount of capital chasing these assets and investment opportunities in these assets, trying to do these deals very quickly. And so big bets, short schedules, a lot of competition equals enormous risk. And we're starting to see that in the litigation practices across the firm. So I'd like to start first with Chris. And Chris, I think it'd be good to just get an overall sense of what you're seeing with respect to data center litigation. I think when you look at the investment cycle here, we're still relatively early in the cycle. And so I think it'd be interesting to hear your perspective on how much activity we really are seeing at this stage. Is it a matter of preparing for what's to come, or are you already on the front lines dealing with major litigation issues?
It's here. Litigation is here. So yes, we're seeing litigation. There has been a lot coming out of data center projects specifically. It's not a surprise. Mark just described the massive outlay of capital. Anytime we see that in the industry, we see litigation to follow. I think, to me, what's a little bit surprising about this is how much we have seen and how quickly we have seen it hit the dockets. When I think about other big infrastructure moments in the country, recent ones like, LNG, offshore wind, sort of like energy transition projects. We all expected litigation to follow, and it did, but it took some time for those processes to start getting billed, for the capital to really be outlaid before at least stuff that we were seeing came to the forefront. With data centers, it feels like everything is dialed up in terms of pace, frequency, and certainly in terms of the total dollars in dispute.
And what type of disputes are you seeing at a high level?
Well, I mean, there's purpose to this panel. So a lot of the disputes that we see mirror a lot of the complexities that we see on the deal side. So certainly we're seeing environmental disputes, and Patrick will speak to the permitting issues that we've been seeing hit the dockets. There's disputes around access to power and the drain that these projects put on the local grids, intellectual property disputes. In my world, in commercial litigation, really what we're seeing are the kinds of disputes that you would expect to flow from large infrastructure projects that are high dollar and are not always the most popular with the immediate neighbors.
Right. So why don't we start there and explore on the commercial disputes side specifically what you're seeing and how for some of our clients who may be looking at this from a transactional perspective, they can mitigate the risks of litigation.
So I would group what we're seeing on the commercial side of litigation into sort of 4 drivers of disputes. One is good old-fashioned greed. The second is tension between public and private partnerships. And what I mean by that is the tension between local governments who want to attract these kinds of investment dollars and the constituents who are not always happy with having them in their immediate backyard. Energy scarcity, so just access to regular access to electricity and energy to power these energy-sucking projects is a source of disputes. And then finally, construction delays and mishaps, which you would expect to see in any kind of major infrastructure project, is where we see most of the commercial disputes so far. And so if I can just kind of give some specifics on what I mean by these. So greed, that's kind of a generalized term, but I think just as an observer of this industry, you see massive capital outlays. You see every couple of weeks, some multi-billion-dollar project that is announced. And circling around those deals are people who have visions of generational wealth. If they can be connected to this project, they're gonna make money. This is their retirement plan, and that fuels disputes. So let me give you an example of a couple of things that we've seen recently. Most of these projects have advisors involved, some sort of broker who is set to find financing or an investment partner or a long-term lessor for the project. Those kinds of agreements usually are paid based on a percentage of the closing value of the deal. It is becoming increasingly common for there to be a deal announcement. Congratulations, ABC company closed this $12 billion financing for a data center and wherever. And out of the blue comes some advisor that nobody in the deal has thought about anymore who says, "That's wonderful, where's my commission?" That kind of thing has always happened, right? That's not like a new sort of dispute. But I think what we're seeing is, given the dollar amount of these disputes, it's worth it to take a flyer on a case that may be a little flimsy. When we think about litigation risk, we think about a mountain controversy and likelihood of success. So even in these cases, if the argument for a fee is 10, 15% winner, when you're talking about a 2 or 3% return or recovery on or commission rather, on a $10 or $100 billion project, you're talking about real money. So we're seeing some more kind of, aggressive interpretations of contracts. And this is not to pick on brokers. The flip side of it would be, people consummating the deal don't want to part with 2 or 3% of a 10 or $100 billion deal. This year, we've worked on 2 of those disputes, both of which were confidential and both of which were really shocking to the investors because they viewed the claim by the advisor as being really flimsy. It's not just a matter of the exposure, the fee exposure, but when somebody shows up on the eve of closing and has their hand out and says, "I'm entitled to a fee," probably there's been some reps about whether or not there are any contingencies on the deal, and then that creates risk on the deal itself. So A similar example would be like an exclusivity agreement, kind of like a pre-deal term sheet that is sort of loosely binding but gives one party exclusivity. We're seeing people coming out of the woods and saying, wait a minute, even if the deal was consummated on different terms than were contemplated by the exclusivity agreement, the partner wants a piece of it. So the takeaway here is just so much effort gets put into papering up big dollar project finance agreements, but sometimes some of the preliminary agreements, the fee agreement might be a form that the broker passed on to somebody, wasn't really carefully vetted. People weren't thinking about the different machinations of the deal and what would happen if a different kind of deal was done with a different person. Those kinds of agreements, the pre-deal term sheet, the broker agreement, those deserve scrutiny in these projects because of the amount of controversy that can flow from them.
Thanks, Chris. And I mean, one of the things that's interesting is to think about the way the assets are moving to get these deals done. Often you've got a piece of land that's going to pass through 2 or 3 hands and change control before it lands with the developer and the capital partners who have the wherewithal to develop a project. And each time you transact on that land, the risks that you're describing are going to be present, and you have to deal with them at each point of the way.
And it adds complexity to the dispute. Which deal is the fee earning deal? Is it the preliminary one? Is it the final one? How do you calculate a fee on that? A lot of times those fee agreements are not built for the kind of complexity that you're describing. And so we advise that they get a special look on these kinds of projects.
Okay, well, thanks, Chris. So now we'll move to environmental, which is particularly relevant to what's going on at V&E. We're involved in some of the largest power projects across the country to power data centers, and this is a huge issue of concern. So, Patrick, why don't you take us through what you're seeing?
Great, thanks, Mark. Hello, everyone. I'm glad you're here in person, and those online, well, thank you for joining us as well. I just have 4 slides that I want to go over with you today. The first one and the second and the third one really define the problem set. And the 4th slide talks about where we go from here, help you all to think about looking around corners in terms of anticipating how these problem sets might manifest themselves in future situations. The first slide is, what you need to know about environmental litigation. Oftentimes environmental litigation is kind of the tail that wags the dog. And what I mean by that is, you might find a community who just doesn't want a data center in their neighborhood, but they're not organized, they're not qualified to really attack city hall or state government to try to get the thing to go away or not be built. But they're unhappy about the fact that there is a data center there, and it could be noise or light pollution, or the idea that the community is already overburdened by development, or I bought this place out in the farmland to be quiet and alone, and now we're having this big facility being built. All these different reasons, many of which have nothing really to do with environmental law. There is, however, a group of very qualified environmental public interest groups who are happy to parachute in and find those local people who oppose the data center and then bring to bear these environmental laws as a method to effectively attack the development or the continued operation of the data center. So you have to kind of have that in mind. I mean, the environmental groups are very much focused on environmental issues, but they're really enlisting environmental litigation in support of a broader objective, which is not this data center, or at least not here, right? So that's something to keep in mind. And what that means in terms of looking around the corner, which is our 4th slide, is you can get the best permits in the world. You can have the best team in the world to get all of the right pieces of paper from everyone you need to get a piece of paper from, but you may still have opponents in the area, in the community, and you may still have these national environmental groups who, again, are very qualified, very effective, sweep in and begin to cause trouble for the development or ongoing operation of the facility. So that's the first thing. Just the general context isn't that these things are necessarily terrible for the environment. It's that people, for whatever reason, are beginning to be motivated and activated against big data centers. And you can read the papers as well as I do to try to figure out why that may be the case. From my experience so far, it's very rarely because they're dangerous to public health from an environmental perspective. So that's the first slide, just a general background. Well, then next two slides, how does that manifest itself? What does it look like to have an activated community group with a well-qualified environmental group coming in and looking at your data center? Well, there are two ways that we're seeing so far that litigation is being used. You can appeal the environmental permits that were issued to the facility, or you can bring what's called an environmental citizen suit and argue, well, we don't really care what kind of permits you got. You didn't get the right ones, or there's some other violation of law. So you have two different modes of using litigation to bring environmental complaints to the forefront. And we see a lot of both of them. So this slide here, this permit appeal slide, go one slide back. Oh, yeah, sorry, yeah, I can do that. You just see people beginning to appeal permits at the state or local level. You get a Clean Air Act permit, then you'll see a permit appeal of that Clean Air Act permit brought before the state. The company has to defend it. The state has to defend it. It takes time. Those appeals are almost never successful. They're hard to win for these environmental groups, especially if you have a good permitting record. But they create significant risk because if that permit is found to need to go back to the agency to be reissued, it could shut down the facility. So as Chris was mentioning earlier, right, you may have low risk propositions, but high costs. And so the overall risk is high, and therefore companies are very much focused on these kinds of permit appeals. I'm not going to go through all these examples. You have the slides. We keep an eye on this. These are going on all over the place. We've worked on a couple of major ones as well. So that's the permit appeal angle. Then real briefly, I'll turn to the citizen suit angle. This is, let's say you have a permit, or maybe you didn't get a permit. These groups and these communities can come in and say, well, you got the wrong kind of permit. Oh, thanks. You got the wrong kind of permit. I was clutching onto it with my hand and I wasn't letting you actually operate it. Okay, thank you. These groups will come in and say, for example, under the Clean Air Act, you got the wrong kind of permit, right? So we're going to bring a lawsuit. Here's where things get really interesting. These are in federal court. These aren't just appeals to state and local governments who issued you your approvals. These are in front of a federal district court judge. The stakes are high. These groups are very good and they're very aggressive, and they may do things like move for an emergency injunction to stop the facility from operating, or move for a preliminary injunction. When you've got a multi-billion-dollar investment sitting there operating, even the slightest risk that a federal district court is going to order you to turn off the data center, those can be existential risks for companies and for data centers. And the environmental groups understand this. And so they are leveraging these kinds of cases to do their best to make sure that their stakeholders are heard. So those are the citizen enforcement suits. We've got a couple of the big ones underway as well. And it's kind of all hands on deck, technical, business, legal. It's a real set of risk for companies who have to face these kinds of lawsuits. Before I turn the page and go over to sort of looking around the corner, what's next? Any questions about permit appeals or the motivation of environmental groups to bring these kinds of cases or citizen suits? Any questions?
Is there any construction in New York, or are they suing the governor yet, or what's going on there?
Is there any construction going on in New York? So we also do project development. I have a list of states where you shouldn't do business, and New York is near the top of the list. I'm not going to name the other ones, right? There are a bunch of states up there. It's just hard to build, and Jeff will tell you how hard it is to build energy projects up there, even electric transmission. But yeah, New York is not building data centers, right? And that's just a whole political angle aside from these environmental litigation suits. Good question. Other questions about these environmental groups and so forth? Permit appeals? Yes, ma'am.
Do you find that some of these situations are going after, say, groundwater conservation districts that maybe have given a permit for water supply wells to supply water to a new data center?
Sure, that could be a permit appeal, so it could be a local permit appeal at the state level. You don't really going to see citizen suits on that because the safe drinking, the federal government doesn't have a lot of oversight over groundwater withdrawals, making sure the aquifers are protected through drilling correctly. But other than that, not a lot going on in terms of water allocations and use. So you would see that more as a local permit appeal, I think. And we are beginning to see those pop up from time to time. Yes, sir.
Do you ever think we'll ever see any of these projects be more environmentally friendly, meaning just money to kind of satisfy these things? Will you ever see a LEED certified data center or anything like that?
So look, my experience is these companies are these hyperscaler companies are generally fairly green. Right? I mean, you think about their public persona, you think about how they like to be seen by the public. They do build facilities. For example, this one that I have in mind has a really, really fantastic sort of closed loop cooling system that doesn't require a lot of water to be used, right? And some of the best air pollution controls on the turbines and community engagement and all the things that you would expect a good developer to do doesn't count for anything because there are bigger issues at play than strictly just the environmental aspects. Well, look, let's turn the corner here real quickly. Because this kind of litigation is driven by ideology, right? Environmental issues in support of an ideological driven point of view and perspective, it's tough to get a handle. Like the gentleman just asked, it's tough to get a bulletproof permit. You may have all the bells and whistles. This may be the best developed, the most environmentally friendly facility that's ever been built. Nevertheless, those larger concerns, those larger ideological concerns, community concerns will still be there. And so, litigation defense is increasingly just a part of doing business for these things. So you have to, number one, get all the right permits, get the best permits that you can get, design and develop the facility with the best possible environmental controls, but then you almost have to expect to have to deal with a permit appeal or a citizen suit. And that's just a part, unfortunately, of building these things going forward. So look around the corner, the news is a little bit grim, right? We're at the very early stages of all this. I think the news is going to get worse before it gets better. But folks should just be aware of that as they begin to think through developing data centers. And with that,
Yeah. Well, Patrick, just before we move on to Jeff, I think people would be interested in hearing, are you seeing any patterns to the kind of data center developments that end up attracting environmental litigation versus those that are getting through with a relatively clean shirt?
yeah, so speed is paramount in developing data centers. And the faster you go, right, the more likely it is that you're not going to be getting your environmental permits in what I would describe in a traditional way, right? They don't have 2 years to wait around, right, to get the best kind of environmental permit or the kind of environmental permit that would really withstand very, very close scrutiny. So centers that have that kind of time are going to do better in litigation. Data centers that have to move very quickly. I'm not saying they're cutting corners. I'm not saying they're doing things unlawfully. They're just not maybe doing things in a traditional 1 to 2 to 3 year project development timeframe. Those are the centers that are probably going to be the ones that see more opposition because to these environmental groups, that kind of permit doesn't look like what they're used to seeing. And so they're going to have questions, and those questions are going to turn into opposition.
And other than having a strong permit record, is there anything else they can do to mitigate the risk? Does location selection kind of change the risk profile, or how do you see that?
Does location, certainly there are states that are unfriendly to development in general, and they are also unfriendly to data centers. So if you try to put a data center in one of those states, you might not even get past the starting gate. The state might be the one, right, who is opposing the project. But if you get into a state that is willing to do data center development, I don't know that there's much of a difference, say, between, Texas or Mississippi or Georgia or Virginia. Those are states who develop these kinds of data centers. I'm not sure there's much of a litigation risk difference in those states based on environmental issues.
Great. And we've got one last question from someone online. It looks like one of our international attendees who says, we're seeing permit requirements change post-contract signature, which then affects the design parameters of the build. For example, fire regulation on lithium batteries forcing a return to lead acid. Are you seeing similar issues in the US?
Yes, yeah. So from the air perspective, from the Clean Air Act perspective in particular, the Clean Air Act permit almost always has to be negotiated and obtained before maybe you even know exactly what you want to build. So that's always been a feature of long lead time environmental permits like the air quality permits. And so that's just a natural part of the process, is reacting to changes in design, reacting in changes in regulations, reacting in changes in local air quality. Until you get your final permit and get the facility built and operating, there's always a lot of uncertainty. And that just gets managed by good permit, engineers, good permit consultants, good permit lawyers.
Well, thanks, Patrick. Very interesting stuff. So now we'll move on to Jeff Jakubiak. Jeff, I know it's been a very busy summer at the FERC, and we'd love to hear your perspective on where things stand.
Thanks. So, Mark, if you could flip over a couple slides, the FERC jurisdiction. Let me just sort of lay groundwork as to where things have been with FERC and where they're going, because I think it's important context to where I see the litigation going. For 80 years, utilities just planned their own systems. They planned their generation, their transmission, all to serve load. In 1996, that all changed. FERC opened up the transmission lines, required what's called open access, changed the transmission wires from being private roads to essentially paid toll roads, but publicly accessible if you paid the toll. And then building on that, in 2003, they opened up the transmission lines to generators interconnecting. Historically, there had been, even though they opened up the lines to use of the transmission, there had been a mismatch of regulation by each utility as to how they approach generation hooking up. So they standardized those in 2003, modified them a little bit a few years later for large generation. So FERC has viewed transmission connections as being something that's subject to their jurisdiction. So they can mandate the rates, terms, and conditions of the transmission hooking into the generation. And so we've been that way for about 23 years now. FERC did not regulate load interconnections. Load historically has been fraction of generation. You have generating units, 5, 10, 20 megawatts. Those were small, 500,000 megawatts, pretty large. Load, maybe a large mall would be 5 megawatts. I mean, the size of a small generating unit. Maybe you get some mining facility that's a little bigger. But we're now talking with these data centers, loads that are 500, 1,000 megawatts, even larger. So multiples of the size of load interconnections, the demand interconnections that people have seen historically. And so Amazon Talon was one of the first situations where Amazon wanted to buy nuclear power from the Talon Susquehanna plant, sited at the same location. The power sale was fine, regulated by FERC, but already permitted to be done. Talon had to change the terms of its interconnection agreement with the local transmission system operator. It had to reduce the amount that it would net put onto the grid, or more accurately, increase the amount that it could keep off the grid of its power and send it essentially out the back door to Amazon. A lot of opposition came in from transmission wires companies in the region saying, if you're sending this power behind the door, it's not going to the grid. I'm not getting paid for you using the grid. FERC came back and rejected the change that Talon needed from what is essentially a technical fault standpoint, but it made it clear we have a problem here. We, FERC, don't know how to deal with these new large loads. And we've got to figure out a system because we've got this mismatch. Talon and Amazon rejiggered their deal so it worked. They didn't have to modify the agreement. They didn't have to go back to FERC. But it set the stage and it set the ball rolling down the hill. How are we going to deal with these massive load interconnections? There was litigation, this PJM show cause order, show cause as to why your rules are sensible and shouldn't be changed. And then the Secretary of Energy jumped in late last year saying, FERC, you need to figure out what you're going to do with these large loads, recognizing there's a combination of factors in play here. So a month ago, FERC issued an order to the 6 regional transmission operators in the United States, which cover New England, New York, the Midwest, Mid-Atlantic, and California. So not all the US, but about 2/3 of it geographically, and said, you need to look at your rules for connecting generators, or excuse me, connecting large load, quote unquote, which they said probably is 50 megawatts or more, read as data centers, to standardize the procedures to make them more efficient, to not discriminate, to promote efficiency. All these compliance filings are coming in October and November, and we'll see what each region does differently. FERC recognizes you can do things a little bit differently based on regional practices, standards, maybe those sizes in some regions are going to be different from others. But that is going to be at the forefront of where the litigation happens. Every one of these filings is going to be contested. The generators are going to have views. The transmission providers are going to have views. The load are going to have views. The state regulators, which are parties to FERC proceedings like anybody else, will have views. And you're going to see a lot of litigation come out of these proceedings. There are already battles being fought at the regional level as to formulating what's going to come in these filings in October, November. All of those, I guarantee you, dollars to donuts, they're going up to the courts of appeals. And it's going to be 3 years before we see how it all plays out. Probably will be remanded, probably another 3 years before all the dust settles as to how these rules are set, which will direct how load is interconnected, how easy it is, whether certain load gets first rights in the queue, whether they have to stand behind other people who have come before them, any preferential treatment or whatnot, all going to be litigated. On the micro level, we're seeing litigation as to individual utilities. We get data centers wanting to hook up individual utilities. The utilities and the data center reviews are not moving quickly enough, or they're requiring things that the data centers think are unreasonable. Utilities, on the other hand, take the position, I got to make sure the lights stay on. I'm not cutting corners. I know you want to hook up in 6 months, but it just isn't that fast. So you got massive contention here, both at the macro and at the micro level. Some of it is just starting to bubble to the surface. I don't think it's really going to hit ahead until next year, but it's coming.
Thanks, Jeff. So, go ahead.
See a lot of those coming forward soon? Or?
So the question is whether they're rate cases. By background, rate cases is the term used for whenever a regulated entity goes to its regulator and says, I want to change my rates. My costs have gone up. You need to allow me to charge more. Those are coming through. Those are one of the issues that FERC actually told these regional operators you have to address in your filings in October and November. How are the costs allocated? I mean, let's be realistic. It's almost always about money. This time it's very much about money. The entities on the system don't want to pay for the system to be upgraded to accommodate the data centers. The data centers, as I found, are happy to pay their fair share. There's a question of what is the fair share. And of course, if some costs are not fully borne by the data center that seem to spill over into the utility, they are going to go for rate cases.
Thanks, Jeff. So those FERC orders that apply to the RTOs, which I think accounts for about 2/3 of the US. Right. Could you talk a little bit about what's going on in the rest of the US and how those markets are playing out?
Well, yes, the rest of the US, FERC hasn't taken a command and control. Let me back up a bit. FERC has jurisdiction in the lower 48 states over all aspects of electric transmission and generation at wholesale, sales to resale, outside of ERCOT, which is about 85%, but not all of Texas. These RTOs, as Mark correctly notes, are geographically about 2/3 of the country. In the rest of the third, my personal view, FERC thinks things are going okay. They haven't heard a lot of complaining about the speed to hooking up. and are allowing those utilities to do it themselves. But the chair of FERC made it abundantly clear in her concurrence when these orders issued last month, we are not, something to the effect of, we are not blind to the fact that these issues go beyond the RTOs. We're just not taking any action at this time, which I read as, you better shape up, fly right, or continue to fly right, or we will come in and command and control. So right now, outside of the RTOs, it's really utility by utility disputes. They haven't been filed at FERC. I think if and when utility-specific disputes get filed at FERC, FERC will come in and will take action. The chairman has made it abundantly clear that this is important to the FERC, this is important to the White House, that these data centers get connected.
And Jeff, for some of our clients who are planning projects or looking to invest in projects, is there a consensus view on where things are likely to land with respect to some of these major focal points under the order, like BYO load for new data centers?
The very good point. So let me explain the BYO load a bit. There are really two aspects to getting load, read as data centers, hooked up. One, you have to have the transmission infrastructure to connect it, and you have to make sure that transmission infrastructure is robust enough to carry the electrons in whatever directions it needs to go. I mean, think about building a massive arena down the street from in your neighborhood. The streets aren't going to handle the traffic, right? You got to build out the roads. But by the same token, you also need the power. Just because you hook up to the grid doesn't mean there's enough power on the grid to supply your needs. So a lot of these data centers, as you heard, are co-locating, building generation with the load, same location or nearby in order to minimize the transmission that's needed. Most of these regions are starting to go to a BYO generation approach, or at least if you bring your own generation, we'll fast track you. And I think we're going to see a lot of that in November. But people who have already were in the queue to hook up, whether in load or generation, and mind you, it's the same individuals that study both of those on the transmission side, they're going to take the position, I don't care if this guy's bringing generation to supply his load, his needs to be studied like mine. I got here first. You study me first. I get connected first. And that's going to be a very active battle.
Great, super interesting. Thanks, Jeff. Lastly, Jeff Swigert, one of the themes we hit off the top was the level of competition here, and one of the arenas that's playing out in is in IP litigation, and Jeff covers some of the most active dockets in the country. So, Jeff, I'll hand you this, and why don't you take us through it?
Great. Thanks, Mark. So data centers have been targets of patent litigation for many years now. In early cases we saw against companies like Equinix, NTT, and Lumen, they were targeting cloud storage and networking technology. A more recent trend seems to be targeting the physical infrastructure of data centers, which really makes sense since you see the scaling and the build out of data centers in response to the global AI demand. We're also seeing what has already been spoken about, a huge influx of cash, and patent litigation often follows where the money is. And so data centers are these high value IP targets now. There's also somewhat of a confluence that's taking place between the scaling of data centers and also a rise in patent litigation in general. Over 2024 and 2025, there were double-digit increases in the number of patent cases that were filed in district court. And this really reversed a trend going back to like 2017, where there was fewer patent cases being filed. There was a recent report put out by Lex Machina about patent litigation in 2025 that also showed over the past several years the aggregate amount of damages awarded in patent cases was exceeding $1 billion annually. And in fact, in 2024, they set a record of $4.35 billion being awarded across 94 cases. There's a couple of cases that are particularly relevant, perhaps to data center operations. One of those cases from 2024 was against Samsung, who had memory modules. These are DDR3, DDR4 type memory modules that were found to infringe, and the plaintiff in that case was awarded $118 million. There was another case against Amazon Web Services, where the plaintiff was awarded $512 million. So those awards are on appeal right now. We'll see if they actually hold up. But kind of the takeaway is that there are large sums of money that are being awarded in these patent cases and making them very attractive for patent owners to go after them. Another kind of noteworthy event that's taken place over the past couple of years for patent litigation is that as the number of cases have increased, there has also been a mechanism at the USPTO that provided an alternative venue to challenge a patent outside of district court that has become less available to patent challengers, accused infringers. So in 2011, Congress passed a law called the America Invents Act, and it created this proceeding called an inter partes review, an IPR. An IPR allowed for a patent's validity to be challenged based upon patents and printed publications. And the institution of those proceedings fell off in 2025. They were initially intended to be by Congress a proceeding that was efficient, that was faster, it was cost effective, provided a specialized look at the patents from patent judges. But there were changes that were made at the USPTO that caused the institution rate for those proceedings to drop in January 2025 from over 80% to under 20% in August 2025. So that's had a huge impact on patent litigation. I'll mention that again here in just a moment. The one other point I wanted to flag about patent litigation is that Texas continues to stand out as a hotspot for patent filings by NPEs. And a recent report was put out that looked at the patent filings over 2026, just the first part of this year, and found that roughly 2/3 of patent cases filed by NPEs were filed in one of the districts in Texas. So an NPE just stands for it's a non-practicing entity, meaning they don't make a product or perform a service that's covered by the patents that they own. And they can kind of fall on a spectrum of, maybe it's a one-off inventor that could never commercialize their particular idea. But oftentimes, NPEs are very sophisticated and well-funded entities that are patent aggregators, and they purchase these patent portfolios for the sole purpose of monetizing. So that's a couple of examples that we have here. A very well-known NPE in the data center space is Valtris. And Valtris acquired in 2021 about 2,000 patents from Hewlett-Packard Enterprises. This was a portfolio that was nearing expiration, and so Valtris immediately began, asserting these patents against different technology verticals. And in 2024, they went after data centers for their cooling technology. And I thought Patrick mentioned the really cool closed-loop cooling system. I don't know if that's necessarily one that's covered by these patents. I'm sure Valtris would think it is. But going after the cooling technology within data centers, and in 2024, they filed 7 cases in the Eastern District of Texas against data center operators. Now, a really definitive moment within this Valtris campaign came when Vertiv, who was one of the cooling equipment suppliers, not a named defendant, intervened in NTT's case. And out of all of the cases in 2024, most of them settled relatively quickly, but this Vertiv case continues on. It's actually set for trial later on this year in September. And so we're watching to see how those patents ultimately hold up. So with the Vertiv case, they also filed as a defensive measure, not only intervening in the case, but 2 declaratory judgment actions and 3 IPRs. So we think it's noteworthy that the Valtris model for NPEs to acquire these patent portfolios and then inserting them later on against data centers is a model that has existed within patent litigation for a long time and is likely to continue on against data centers going forward in the future. There's also another type of case that we refer to as just competitor cases, and we brought up an example here between Midas Green Technologies and Green Revolution Cooling. And this is a case where 2 competitors are going against each other and accusing each of infringing their patents. Competitor cases have a little different feel to them because oftentimes there's allegations of copying each other's products, and it's much less likely that these cases are going to settle for less than the cost of litigation like a typical NPE case might. But to me, the most important event actually happened between the GRC and the Midas cases at the USPTO. So let's go back in and dig into this just a little bit more. The reason why that the IPR institution rates collapsed in 2025 had to do with a change in policy and the way that these proceedings were instituted. So historically, what would happen is that a patent challenger would file a petition, and then after 3 months, a patent owner would have the option, they wouldn't have to, but they could file a preliminary response. And then after another 3 months, the board would look at the merits of the petition, and then they would also weigh factors related to discretionary denial, and then they make a decision on institution. Well, in early 2025, the USPTO changed its policy that took the discretionary denial aspect away from the board and created a separate briefing round that takes place after the petition is filed, where a patent owner can immediately argue for discretionary denial after a month of the petition being filed, and then the patent challenger responds to that. And it's now within the sole discretion of the director as to whether or not these petitions should be denied for discretionary reasons. So as you can see that over in this graph, the last couple of years or since this change in 2025, the director has found a lot of reasons for denial. And we've actually inverted the number of institution granted versus denied within that time frame. And this change in policy, just as an example, has had direct impact on both the Valtris campaigns and the Midas and GRC cases. So for the Valtris campaigns, they had brought earlier campaigns from the HPE portfolio since 2021, but defendants were having some success filing IPR petitions against those. But that has effectively gone away completely because all 3 of Vertiv's IPRs that were filed against Valtris patents were denied at the discretionary denial phase, and the merits were never considered. Maybe even more surprisingly is that in the Midas and GRC cases, there was actually a petition that was granted by the board, but the director sua sponte vacated that decision a couple months later because trial was only going to be 4 months away. So this off-ramp using IPRs from district court litigation has been mitigated substantially, and it's going to continue to impact the patent litigation landscape going forward. Just mention one more kind of thought about future patent litigation related to the number of patents being filed. Obviously, that there is a boom in patent filings around AI and data center technology. The notes to take away here, though, are Chinese companies are outnumbering U.S. companies in patent filings by a significant margin. And the concern here is kind of twofold. I mean, one has to do with ownership. Where are these patents ultimately going to land? If they are ultimately finding their way to NPEs that are going to be asserting these, then data centers, unfortunately, have a long future of looking forward to patent litigation. And there's also another aspect about quality. So just the number of cases, or the number of patents, rather, that are being filed, there's a question about whether or not that there are protections being filed over legitimate innovations that are coming about, or whether that there is a process just amassing a lot of patents that could be used in future litigation. There's also this issue that, again, the USPTO appears to be at the center of, where a landmark case by the Supreme Court called the Alice decision presented some strong obstacles for software patents from issuing. And the USPTO has recently taken initiatives to provide guidance and even encouragement to patent owners to be able to have software patents being issued. But currently, the Federal Circuit and district courts are following the Supreme Court precedent, and so there's a question as to the divide that's creating over these software patents and their validity. There's also, just as kind of a final note, there's some congressional activity in the works with the Patent Eligibility Restoration Act. It's been in the works for some years now, but has yet to escape the committee, and so that's something that we continue to keep our eyes on.
Thanks, Jeff. And so before we move on from IP, I think the audience would be interested in hearing, is there anything that data center developers or operators can do before litigation starts to limit their exposure to some of these patent suits that you're seeing?
I don't know that they can limit what they're doing to get sued, just because there's a creativeness on the behalf of NPs and patent owners to be able to read their claims that are covering the technologies that exist out there. Texas is obviously a popular forum, and there are certain jurisdictions that have some plaintiff-friendly rules, or at least perceived that way. And so there's efforts that are made to make business decisions that would keep a company from being sued in one of those plaintiff-friendly districts. And there's some success with that, but once again, plaintiffs can also get creative with their jurisdictional arguments as well. And I'm going to show a little bias here as a Texas patent litigator, but we think there are really upsides to actually having suits in Texas, as far as like the speed to resolution, and also having very patent knowledgeable judges on the bench that can actually be in the benefit of an accused infringer.
Good plug.
And just to go back to Valtris and GRC quickly, where there's this risk of operators being sued for technology that might be supplied by someone else. What should developers and operators be doing to protect themselves by way of indemnity or other provisions in vendor contracts?
That's a good question. Some of the work we're doing is looking into those indemnity provisions within the agreements between the suppliers and the operators, and just some words of caution, just making sure a general indemnity provision oftentimes may not be enough, that we should really examine those provisions to determine whether or not infringements and different types of infringement, as far as like multiple vendors working together in combination, are covered under certain indemnity demands, and the specific events that have to occur to be able to trigger that indemnity. So there's a lot of groundwork that can be laid that actually would be helpful to the operators in trying to get the manufacturers or the suppliers to step into those litigation rules.
And I imagine control's also an issue as well. There might be circumstances where the trade-off for getting an indemnity is to pass control of that litigation to your vendor, and in some circumstances that may not be to your advantage.
Right, and the Valtris case kind of speaks to that well, in that Valtris was the way that they had drafted their complaint actually accused many vendors, and so for Vertiv was the only one that really stood up to be able to take that indemnity role. But there could be others that could step in there. But a plaintiff is going to want to go for the deepest pockets, and so they're trying to get outside of just the supplier of the equipment and trying to get to that operator. So they're not going to make it easy for them. Great,
thanks, Jeff. So we've got a question from online. So question for Chris on construction litigation. Are you seeing that either owners or contractors are making business decisions generally to avoid litigation, purely not to get blacklisted from future projects? I think the question there is, are people avoiding certain projects, construction projects, because the litigation that might attract would be damaging to reputation? Or
that's probably a better question for you. I see it when there is litigation, so I'm not sure about the front end decisions that owners and contractors are making to try to avoid litigation. I will say that a lot of the construction litigation that we see in the data center world is around power. I mean, it comes back to, is there adequate backup power? Are the systems also tied to IP? Are they adequate to deal with contingencies? And what we are seeing is a lot of thought around how you allocate risk for power outages. So there's operational ways to do that through backup generation and the like, but also risk through consequential damages and the like.
Yeah, I mean, that's in my practice, I think that's a huge focus, and it's obviously looking ahead to the types of disputes that these guys may end up handling. When you think about it, the level of the value that's going into these data centers, the investment in the chips, which are multiples of the cost of building the data center itself, and then obviously the revenue models that have to support that investment in the chips. those create massive risks of claims if things go wrong on reliability of power or delay in startup of a project. And so in planning out the liability provisions of construction contracts, development agreements, data center leases, it's really critical, and we act mostly on the developer and sponsor side to pin down those liability provisions, make sure you have tight sole remedy clauses, make sure liability caps are appropriately sized to the level of payoff that you're getting from the deal, which is often not going to be proportionate to what a data center tenant investment and revenue is, and then consequential damages as well. So I think there's more of a focus on those issues than ever before, just because of this disproportionate relationship between some of the contracts people are entering into for, say, a powered shell versus the value of the business that's being conducted within that powered shell. So we have a question for Patrick. What's your take on how recent departures of career staff at DOJ and EPA affect the capacity of the federal government to be appropriately helpful to project proponents in responding to citizen enforcement suits?
Yeah, it's a good question. There has been an outflow of career staff from DOJ and EPA enforcement, particularly in this administration. Many of those people have gone to environmental groups. So they've taken their chops that they've developed at EPA and DOJ, and now they work for Sierra Club, the Natural Resources Defense Council, Earth Justice, Environmental Integrity Project. So the outflow of staff actually make litigation more likely, because these used to be federal prosecutors and federal enforcers. Now they work for the citizens groups. Those departures haven't really affected the ability of political management at EPA as a matter of policy to be as helpful as they can be to help companies respond to citizen suits. I mean, if the citizen suit is absolutely legitimate, I mean, there's not much that political management is going to be able to do to help too much. There was a memo that came out last December that said in appropriate cases, EPA and DOJ could intervene in those citizen suits and work to preempt them. So if that's done early in the proceedings, it may be that the citizen suit can't get filed. Many of you may have seen in the papers recently that the Department of Justice has actually intervened or moved to intervene in the XAI matter in the Northern District of Mississippi, and argued that citizen suits cannot proceed if the federal government opposes them. So, I don't think that the departure of staff have really affected the ability of DOJ and EPA to come in and make those kinds of arguments. Quite the opposite. Departure of staff make it more likely that litigation will continue in a vigorous way.
Great, thanks, Patrick. So we're about to hit the top of the hour. I know we started with Chris, and so perhaps we'll finish there as well. Chris, having heard what all our colleagues have had to say today, and just thinking generally about where we're positioned right now in the cycle, do you have any final thoughts on how our clients can be protecting themselves with respect to potential future litigation going forward?
Well, I mean, I just think that as we've tried to convey today, the complexity of the deals are a reflection of the complexity of the litigation that flows from these projects. So the silos of expertise that you need to get one of these projects from start to finish on the deal side are the same kind of silos of expertise you need to protect yourself against litigation. So the complexities around power, the complexities around permitting, the complexities around IP all spin off disputes that flow from those controversies. Also, it's just, we're in this world where, as we started, there's a lot of money. So a lot of money creates a lot of opportunity for risk and litigation risk. And there's also an odd tension between a country that is hungry for data centers and capturing the AI business and data center business, and then local communities that don't love it so much. And so that tension between the desire to grow but the not in my backyard thing creates a lot of these permitting issues that come from citizen suits. We didn't hit it, but there are other examples of just local governments pulling the rug out from under developers. Here in Texas, just outside of Waco, there was a widely publicized example of where Hill County passed a moratorium on the data centers after a huge data center project was already funded and permitted and ready to go. There was a lawsuit over that. That was considered an inverse taking. At least that was the developer's allegation, because the property rights were basically divested by a change in political will. That case settled, but there's other examples. Amazon is in one in Georgia. So even in places that you think of as being developer friendly, all politics is local and politicians can be fickle. So there's always this uncertainty that we're going to see flowing out of these deals until there's some sort of, settling out of a regulatory landscape.
Great. Well, thanks everyone for attending. I think the next session in this series is coming up in a couple of weeks, and we hope you'll continue to join us. Thank you.